Okay, so picture this. You get written permission from your homeowners association to do a project. You spend the money, you do all the work, and then you get a violation notice for that exact same project. It sounds completely impossible, right? Well, today we're going to dive into the strange and very true story of one homeowner who found himself stuck in that exact bureaucratic nightmare.
So that really brings us to the big question here. Can you actually get hit with a violation for something your HOA has already approved, in writing? You'd think the answer would be a simple, obvious no. But as one homeowner found out, the reality can be way, way more complicated.
So let's meet the guy at the center of all this, Myron Colvin. Back in 2019, he wanted to install some concrete pavers on his property. And he did everything by the book, he submitted a request, and the HOA gave him written approval. So he installed the pavers, and then bam! He gets a violation notice for that very project. It's a total head-scratcher, and trust me, the details only make it weirder.
To really understand how this happened, we've got to look at the timeline. Because when you lay it all out, everything seems perfectly clear. But as we're about to see, that's not really where the story ends.
Just look at this sequence of events. The homeowner sends in his request in March 2018. It gets approved. He has to delay the project, so just to be safe, he submits the exact same request a year later in March 2019. It gets approved. Again. So he finally installs the pavers. And then, not even a month later, boom, a notice of violation. And it's for the project they gave him the green light on twice. I mean, how is that even possible? Well, the answer, at least according to the HOA, was hiding in the fine print of their own rules. This whole mess comes down to how you interpret one very specific clause. Let's take a look. And here it is. This is the sentence at the very heart of the conflict. The rule says that landscaping in this specific area has to be movable by one person unassisted by mechanical devices. This single phrase is the legal hook the HOA used to justify the violation, even though they'd already given him 2 written approvals. So what does movable landscaping even mean? Well, according to the HOA, Mr. Colvin's pavers just didn't count. And their suggestion for how to fix the problem? He could either rip out the concrete entirely or, and you gotta hear this, he could cut it up into little 100-pound sections, a pretty specific and, frankly, weird interpretation to come up with after they'd already approved the plans. So, of course, the homeowner fought the violation. The whole thing ends up in front of an administrative law judge. And this is where we see 2 completely different arguments go head-to-head. One is based on just simple, everyday logic, and the other? Well, the other is based on a very technical legal point. Mr. Colvin's argument was basically just common sense. Look, you approved my project twice. How can I possibly be in violation? Simple enough, right? But the HOA's argument was a clever bit of legal jujitsu. They essentially claimed the hearing wasn't about the homeowner at all. It was about whether the HOA had broken a rule. And since they didn't physically put the pavers in his yard, they argued, hey, we're innocent and this court can't even rule in this case.
So with these 2 totally different arguments on the table, you'd probably expect the judge to weigh the evidence, look at the approvals, and decide who was right about the pavers. But that's not what happened. The final ruling came down to a legal technicality that had almost nothing to do with the actual landscaping.
And there it is, petition dismissed. After all of that, Mr. Colvin lost his case. The reason why is the most important and maybe the most frustrating part of this whole story.
See, the whole case hinged on this legal concept called the burden of proof. In any legal dispute, one side has the job, the responsibility, to prove their claim. In this type of hearing, the person who files the petition, so Mr. Colvin, had the burden of proof. It was on him to prove that the HOA violated a rule.
Okay, so this is the crucial part. The homeowner went into that hearing to prove his own innocence. His entire case was, I didn't break the rule. But legally, that wasn't the question. His job, his burden of proof, was to prove the HOA broke a rule. And because he was only arguing his own case, he never actually accused the HOA of doing anything wrong. Because of that, the judge basically said, look, this court doesn't have the authority or jurisdiction to just declare you innocent. He had filed the wrong kind of complaint. The case was dismissed, not because of the pavers, but because of this critical procedural mistake.
So what can the rest of us learn from this really frustrating situation? Well, it's a pretty powerful lesson for anyone living in a community with an HOA or really dealing with any kind of formal dispute. And here's the big takeaway. Mr. Colvin may have been morally right. I mean, he had 2 approvals in his hand. But in a legal fight, being right isn't always enough. You have to make the correct legal argument and you have to follow the correct procedure.
His case wasn't lost because of the pavers, it was lost because of a paperwork error, a procedural misstep.
And that leaves us with this final, kind of nagging question. Mr. Colvin followed all the HOA's rules for getting his project approved. But when things went south, a procedural mistake cost him the whole case. It's just a stark reminder that in any conflict, understanding the process can be every bit as important as understanding the rules themselves.